All right. Defendant Alec Baldwin's motion limited to preclude argument, testimony, and evidence related to the incident from the Crow.
Thank you, Your Honor. We move to exclude the state presenting evidence of what happened on the Crow as evidence of Mr. Baldwin's state of mind here. The state has said it will not present evidence of what happened on the Crow, but what the state did say is it intends to address and present the theory essentially from the Crow that blanks can kill. Mr. Baldwin knew that, and therefore he's responsible for having the criminal state of mind necessary to prove involuntary manslaughter here. There are 4 problems with that, Your Honor. The first is, let's go back to the indictment. The indictment says that Mr. Baldwin is being charged because it was foreseeable to him that if he didn't check the gun for live ammunition, it says nothing about blanks, not a single word, then his use of the gun by pointing it and pulling the trigger, they allege, could cause significant risk of harm to human life. That was the theory of the indictment. Live ammunition, nothing about blanks. A few witnesses mentioned here and there blanks in the context of an accidental discharge. They get loud, you have to put your goggles on, your earmuffs on, people get mad. There is no testimony in this case about that blanks kill in this particular situation. The case theory has always been, they've said it over and over and over in the papers they've submitted to you, Mr. Baldwin didn't check for live ammunition, he pointed the gun, he pulled it, and then Miss Hutchins died. So they're trying to vary significantly from the theory of the indictment. Problem number 2, causation. Mr. Baldwin not checking for blanks and then pointing the gun did not kill Miss Hutchins. She was not killed by a blank. She was killed by a live round. And all the testimony shows that blanks are very different from live bullets. If Mr. Baldwin checked for a blank, there would have been no blanks there. And so they have a major causation issue as a matter of law in presenting this brand new theory that was not in the indictment. Number 3, there's a foreseeability problem as a matter of law with their intention to present the blanks theory. The Henley case, as Your Honor knows, we've briefed it for you, says the requisite criminal state of mind needs to match or converge, is what the case says, with the criminal act. And what the state's doing here is they're playing apples and oranges. They're saying Mr. Baldwin had the reckless criminal state of mind because he knew that blanks can kill. That was foreseeable to him. He didn't check for blanks, and then Miss Hutchins died. But the act that he's been charged with is not he didn't check for blanks and Miss Hutchins died as a result of a blank. It's that she died as a result of a live bullet. So they're mixing apples and oranges here. They're trying to take what they say is a foreseeable risk and match it with an act that didn't cause the death. So that violates the very clear requirement of Henley that the state of mind and the act converge. That's not what they're saying here. And then last but not least, there is 0 evidence in this case, 0, that Miss Hutchins would have died, or it was expected that she would have died, if you look at the foreseeability cases, if there were a blank in that gun. The foreseeability cases say it's not what can conceivably occur. Blanks can kill. It's not what can conceivably occur. It's what's expected, what's objectively and reasonably expected. There's 0 evidence in this case. They don't have an expert. They don't have a fact witness that can testify. Certainly a fact witness wouldn't be allowed to testify about this, that if Mr. Baldwin had a blank in that gun, in that moment, it would have killed Miss Hutchins. 0. There was no obstruction in the barrel. They keep on saying obstruction in the barrel. There was no obstruction in the barrel. He was feet away, 2 feet, 3 feet, 4 feet away from Miss Hutchins. It was pointed at her armpit. There's nothing in that gun that could have pierced her body. There is 0 evidence. If you look back at The Crow, if you look back at the history of motion pictures, there are 2 incidents where a blank was involved in a death on a movie set. In 1984, an actor put the gun directly against his head, and the pressure pulled the trigger, and the pressure from that directly against his head killed him. In The Crow, so very different from what happened here, miles and miles and years apart. Number 2, in The Crow, what happened was the crew was making dummies out of live bullets. And when the dummy was put in to the gun, it still had residual gunpowder. And the primer got hit, it knocked the bullet tip off, it discharged, And then there was a blank loaded behind that live bullet tip from a live bullet that people on the set were making improperly. Still no criminal prosecution there. Said it was civil negligence, not criminal, but that's not the point. The point is, if you look at what happened in both of those cases in the history of motion pictures, they are entirely distinct facts. The state cannot come in at the last minute and say, blanks can kill, Mr. Baldwin knew that, and therefore he had the requisite state of mind, and they match it up with an act that killed Miss Hutchins. Zero evidence that that would have happened here, and therefore they cannot present it as a theory when there's no causation for it, there's no foreseeability for it, there's no evidence for it, and it's not in the indictment.
All right, thank you.
Thank you, Your Honor.
I'm looking at the indictment that was filed in this case. I don't see anything that says live round. I have it right in front of me. So I'm not exactly sure what Mr. Nickus means when he says if you look at the indictment, he was indicted for that. I'm looking at the indictment, it doesn't say anything about that. So I want to try on occasion to agree with the defense. I want to try to come together. The issue of do we want to have witnesses testify about what happened on the set of The Crow? No, of course not. I intend to present absolutely no testimony with regard to, I expect no witness to say The Crow. But here's why this is relevant. The entire defense is Mr. Baldwin had no reason to believe that there was a live round on set. Well,
Is it on set or in the gun?
I think they've argued both. They've argued that he had no reason to believe that there was a live round on set, that he had no reason to believe that there was a live round in the gun. And here's what they're going to argue. They're going to say this gun is completely inert. He should be able to treat it like a toy because everything is completely safe. Yeah, but the problem is that these safety bulletins and these rules that the defendant failed to follow were created because real guns on movie sets are dangerous. That's the whole reason they were created. And one of the ways that we know that they're dangerous is because if you combine a blank with a barrel obstruction, you can kill someone. It's not what Mr. Nickus said, that there's no reason to think that it would have killed anyone. It would have killed her if there was a blank and a barrel obstruction. I agree with him that that's not what happened in this case. But the point is, real guns are dangerous. The SAG safety bulletin from the Screen Actors Guild says blanks can kill, underlined, bold, exclamation marks. Mr. Baldwin's state of mind is what's critical in this case, and Mr. Baldwin understood real guns on movie sets, even best case scenario for him, we imagine that there's no chance that there could be a live round on set. He still knows they're dangerous, and he understands that the rules exist because they're dangerous. The rules that say, don't point it at anyone, keep your finger off the trigger. Those are all the things that were designed because real guns on movie sets, even if there's not a live round, can kill people. Mr. Nickus can stand up here and say blanks don't kill people. They certainly do kill people. And the Screen Actors Guild Safety Bulletin says blanks can kill. So the problem is that the defense theory is this was a completely inert gun, and the only thing that made it a problem was the fact that there was a live round in it. And that's simply not true. And it goes to Mr. Baldwin's state of mind. It goes to exactly what the state has to prove, which is that he knew or should have known of the risk when he pointed the gun at someone, cocked it, and pulled the trigger, live round or not. He understood that risk. That's what we have to prove, and that's what we're going to prove.
Well, it was in the grand jury hearing that you, the indictment doesn't say it. But
Sure.
you did, to get the true bill, you talked about live ammunition in a gun.
Sure, absolutely. And that's certainly a part of this case, and I don't want to pretend that it isn't. Because the other thing that we know, and we put this in some of our responses, is that when Mr. Baldwin was being interviewed by Corporal Hancock, he actually said to Corporal Hancock, "I'm wondering if Hannah commingled live rounds with her dummy rounds." He knew that there was a possibility that a live round could find its way on set. He didn't even know that Ms. Hutchins had died yet, and he told Corporal Hancock, "I wonder if they were commingled." He knows that these guns are dangerous. And listen, the state isn't... I've had countless cases where the prosecutor has a slightly different theory at trial than they did in front of the grand jury. There's nothing improper about that. We're not amending, we're not trying to add charges at the last minute. I don't understand exactly what the issue is. If there's case law that says that I'm married to absolutely every single theory that was put in front of the grand jury, it's news to me, because I've had courts amend grand jury indictments in the middle of trial based on the evidence. And the evidence in this case is that this gentleman knew that you can't point a gun at someone and pull the trigger, because even if there's not a live round, it might kill somebody. He knew that. And I agree, we don't have to get into what happened on the Crow, but at the same time, the safety bulletins are made because of that. They exist because of that.
Thank you.
A few issues, Your Honor. In terms of the indictment, it was in the grand jury instructions on which the indictment was based, to be clear. There's nothing in the grand jury instructions, in the indictment, in this case, where the actual allegation of the charge is that Alec Baldwin didn't check for blanks, and therefore he's committed involuntary manslaughter. This, in terms of time, Your Honor, and sensitivity to cumulative witnesses and cases within cases, this is a case within a case. It's a hypothetical case about an act that didn't happen, that didn't cause the death at all, with, on top of that, significant questions about whether it's even possible when we know from the history of motion picture it's never happened in this way. Who are they going to testify? Who are they going to have testify, the state, that Miss Hutchins would have died if there were a blank in that gun? What expert witness is going to say that? They don't have a single expert witness. They don't have a single fact witness who's allowed to testify about that. They don't have any evidence that there was an obstruction in the gun. There's literally no evidence of this, and if they want to put on a theory that merges different state of mind with this hypothetical act that didn't cause a death, then we're going to have a very confusing trial with multiple different witnesses being asked, have you ever been on a movie set where a blank killed someone? Have you ever been on a movie set where a blank shot and pierced someone's body in a way that was really dangerous? Have you ever had someone on a movie set shoot a blank in a way that did anything other than cause a little rash or hurt someone's ears or make their eyes have stars in them? We're going to have a trial within a trial about a hypothetical that was not raised until the very last minute and wasn't the basis for the charge in the first place. They have foreseeability issues, they have causation issues, they have evidentiary issues, and there are major notice issues. And in terms of cumulative testimony and wasting of time in cases within cases, that's what this theory is going to become. Thank you, Your Honor.
All right, thank you. All right, the court makes the following ruling weighing whether it has any tendency to make a fact more probable or less probable than it would be without it, and whether its probative value substantially is outweighed by unfair prejudice. I think it's difficult to deal with what I read in the grand jury transcripts about, the theory about the negligent use of a deadly weapon is just his manner of handling, that he shouldn't have cocked the gun, et cetera, et cetera. And then with respect to the alternative, it is that he failed to check the gun. He failed to confirm that the gun I remember the word confirm about live ammunition and, before he pointed it at someone. I think that I will not allow any testimony other than one sentence statement, probably by your expert, Ms. Morrissey, that says that blanks can also kill. But to consider that he failed somehow, that's just going to be up to the trier of fact. I think everybody knows guns can kill. It depends on what's in there, but I think that you can mention it. But that's it. We're not going to go through 5 different questions on tell me how and how serious this is, and he, you know, if he's a gun owner and he's done all these westerns, or not westerns, but all this gun experience, and he should have known it. Just say that, and if you can tie that up, great.